Hi friends, today we will discuss one of the most important aspect in the international taxation, the most favored nation principle. So what is MFN? It usually found protocol in the double taxation avoidance agreement. Suppose you are reading Netherlands Treaty, France Treaty and Switzerland Treaty, you will find MFN clause. So recently in the Supreme Court, the Honorable Supreme Court has discussed MFN clause in case of Nestle. They have discussed, so what was the controversy behind the MFN? Starting from the beginning, the MFN in dispute. So usually people take advantage of MFN clause. Suppose you are come from some having a stake in another entity more than 10%. So as a beneficial owner, you get a dividend from those entity. You can approach MFN clause by taking advantage of 5% tax rate. So this type of MFN clause also favorable in case of fee for technical services, royalty. So maybe you will borrow some advantage for make available clause from another treaty, because suppose you are dealing with the India Netherlands DTAA, but you will find there is a MFN clause, another country has a make available clause, you will get those benefit. So what is the question before the Honorable Supreme Court was, they will discussing whether you will get the MFN benefit without the notification by the CBDT. So automatically can you get the MFN benefit, or you are not a member at the time of signing the treaty, but later you become the member, so whether you will get the MFN clause. So this is the type of controversy we will discuss today. So most favored nation MFN clause. So once we are reading the tax treaty, Netherlands, Switzerland or France, we find there is a MFN clause. So MFN clause क्या है? We will find this MFN clause कि अगर आपने इस सिटी के साइन होने के बाद किसी OECD मेंबर कंट्री को कुछ और ज़्यादा फेवर दिए, तो वो ऑटोमेटिकली दिस टीटी पे एप्लीकेबल हो जाएंगे. तो ये एक इम्पॉर्टेंट क्लाउज है. हम काफ़ी कंट्रीज़ में देखते हैं MFN क्लाउज एप्लीकेबल है डिविडेंड के लिए. इफ़ यू आर बेनिफिशियल ओनर मोर देन 10%, देन 5% रेट इज़ एप्लीकेबल. तो वी हैव टू सी MFN clauses exist or not. फी फॉर टेक्निकल सर्विसेज में डील कर रहे हैं तो माइट बी पॉसिबल योर definition will be narrow or rate will be reduced. Might be possible another country has given a lower rate 10%. आपको that is very much important. as of now I am discussing domestic tax के पॉइंट ऑफ व्यू से 20% FTS का रेट एप्लीकेबल है प्लस सरचार्ज एंड एजुकेशन सेस. बट हमने वी हैव टू सी व्हाट इज द TT टैक्स रेट, दैट इज ऑल्सो 15% और 20%. बट सपोज वी फाइंड देर इज सम बेनिफिशियल रेट इज अवेलेबल टू अस ड्यू टू MFN clause, then we can route that MFN clause. So tax dispute is always from the day beginning whether this MFN benefit is available to us or not. So there is a huge tax controversy. We will discuss Supreme Court Nestle case here. So in short, in the tax treaty, state A bind itself to the state B with respect of favorable tax treatment afforded by it in the future to C. Suppose we are dealing with India, France or India US treaty. USA has MFN clause. France has a MFN clause. Due to MFN clause of India and France, any benefit or clause under the India USA shall be applied to it. So this is MFN principle is there. So certain factor would be relevant to determine the application of MFN. Date of applicability of MFN clause, date of notification issued by the CBDT, status of a state in respect of beneficial tax, income, whether it is dividend income, royalty and fee for technical services, benefit provided, whether rate is reduced or scope is reduced. So this is important aspect we have to see. So what is a controversy? So the MFN clause has always been matter of dispute between the revenue and taxpayer. So India DTA with the Netherlands, France and Switzerland contain MFN clause. A beneficial treatment to these countries when India enter a subsequent DTA with the third country which is a member of OECD, and certain concession are granted to the third country as regard to the scope and rate of taxation. India has signed with the other OECD countries and subsequently Slovenia, Lithuania, Colombia. However, in respect of the later countries, Slovenia, Lithuania, Colombia, when the such treaty entered into force, they were not a OECD member. Subsequently, they become the OECD member. So this is the controversy. So past jurisprudence was in respect of Styria case law. Delhi High Court reversed the AAR ruling, held that the clause 7 of Protocol of India-France DTA did not require any separate notification, and the MFN would protocol consider that not require separate notification. In Styria case, Delhi High Court reversed the AAR ruling. Similarly, Apollo Tyre, Karnataka High Court held that the beneficial provision of MFN clause India Netherlands treaty would be automatically applied. That is also not required separate notification by the CBDT. Similarly, in case of concentrics, this decision is given by the Delhi High Court. So CBDT come up with the circular 3/2022. As per this circular, they said separate notification is required. Circular also clarified that when the TT is signed, third state, such state has to be an OECD member. Right? On the date of signing the treaty, it must be signed, and after the treaty first state. The circular clarified that any decree bulletin by the other passed without the consultation by India is not reflect under this. So this is circular in the month of February 2022. So what is the issue before the FX court? Can the MFN clause be applied automatically without giving notification? Whether certain concession as a regard to scope or rate can be applied? The interpretation of the term is OECD member. So this is in respect of FTS, dividend income or some interest income. So recent Supreme Court ruling in case of Nestle, the discussion ruling they have discussed Styria case in respect of India Switzerland, concentric case in respect of Netherlands TT and Styria in respect of France TT. Ruling MFN clause of various they have a following ground: whether MFN clause can be invoked when the TT country which has India has entered DTA was not a OECD member. So first question is when the TTs apply when they are not a OECD member, whether the MFN clause is to be applied automatically without the notification. So revenue contention is that they said CBDT has to notified. Without notification, treaty provision cannot be borrowed to the domestic law, and at the signing time of signing they should be member, not later on. Suppose the Colombia, Lithuania or Cambodia, they are not member, OECD member at the time of signing, but they become the member later stage. So revenue has said this will they will not grant MFN clause benefit. So what are the contention by the SSE? They said once the MFN clause is a part of protocol of tax treaty, all the provision MFN will automatically apply without the notification, and OECD member is not a play important role. This is the contention of the SSE. So what was the Supreme Court ruling is that they said Supreme Court held that notification under section 9(1) is necessary and mandatory condition for a court. So country want to claim a benefit, MFN must be notified by the and they must be member at the time of signing the court. So Supreme Court judgment have far reaching the consensus for MNC. The ruling will have impact many cases where the India company has made a payment toward dividend, royalty, fee for technical service or interest. So for instances, dividend is remitted by Indian company, they are holding 10% stake as a beneficial ownership, but they have taken a lower rate 5%. So might be possible benefit of lower withholding tax rate of 5% after the factoring of MFN clause. Pursuant to this ruling, 10% will be applicable. So way forward, how the revenue will interpret it and implement the Supreme Court judgment. So whether the Supreme Court ruling will apply retrospectively, it will be question before us. Whether the past concluded assessment or reassessment can be reopened, whether any penalty can be invoked. So these type of controversy may be come up after this Nestle SA Supreme Court case. So might be possible those are enjoying lower rate of 5% in respect of dividend or 10% rate in respect of interest by way of MFN clause, or some narrow scope or narrow lower rate by way of MFN. This question might be possible in respect of all those three countries that I said, these Slovenia and Lithuania and Colombia, because they are not a member at the timing of signing the OECD. So they become the member of OECD after signing this. So most of the dividend, those are paying 5% rate of tax might got taxed 10%, and some they are enjoying not covered in the FTS by way of Netherlands treaty. They are finding their definition is narrow, or there is make available clause is available in the tax treaty. By way of MFN, they have adopted borrow those protocol. So they will fail to establish, and might be their previous assessment may be reopened and tax may be imposed. So hope so I have discussed lot of things, this controversy, and that is got resolved by the Supreme Court, Honorable Supreme Court in case of Nestle. Although this is well established principle by the CBDT circular from February 2022. Now it's clear, once the MFN clause, CBDT has to be notified, and we will give benefit only if you are a third country is a OECD member at the time of signing the tax treaty, otherwise not. So hope so you like my video. I have discussed very important provision and very important provision in very short way. Thank you.